Hey guys, so I just wanted to do a quick video since the plea and bar ruling has been handed down by the Fairfax County Court, and Amber Heard's request to dismiss Johnny Depp's defamation case has again been denied. So this was the third attempt by Ms. Heard to have the case thrown out for purely legal grounds, and for the third time it has been denied, indicating that the case is going to go forward to trial. So I wanted to take a couple minutes just to, one, briefly review the opinion and its basis, two, talk a little bit about what we might be able to learn or infer about the parties, the judge, the case, the posture, and things of that nature based on what we see in this opinion. And then lastly, to answer some of the questions that people are likely to have about what comes next. Is this order appealable? What would that look like? That type of thing. So first, to start off, I encourage everybody to read the opinion. It is, in my opinion, very readable. It's not particularly dense or excessively full of legalese. I do find Judge Azcarati's writing style to be very direct, very plain. It is legal writing, so of course there are a lot of citations and technical terms and things like that that may not be as accessible as your everyday prose. But by and large, I do think that the opinion is pretty understandable, and it's well worth reading through. So as far as the bases for the decision, they were really not any kind of surprise to those of us who have looked a little bit more closely into the law concerning this request. Just to briefly recap, Amber Heard had been asking to essentially throw out the Virginia case on the grounds that the trial in the UK between Johnny Depp and the Sun newspaper already addressed the issue of whether he had perpetrated domestic violence against her, and therefore there was no basis for a second trial in Virginia about the same essential allegations. The problems with that argument, which were laid out by Judge Azcarati in the opinion, were that under the law that applies to these types of requests, they can only be made by people who are the same party or in privity with the parties in the prior case. And obviously the case between Johnny Depp and the Sun, Amber Heard was not a party to that case. She was a witness. So based on the law that's pretty well established in Virginia, she was not going to be able to get the benefit of that judgment in the UK. So based on that, not being the same parties and not having the same essentially interest in the underlying dispute, which in the case of the UK trial was the statements that the Sun had published calling Johnny Depp a wife beater. And then those were not the same statements at issue in the Virginia trial, which involved Amber Heard writing this op-ed in the Washington Post several months later. There were some sort of cute comments that the judge made in the course of the opinion because she clearly viewed these two transactions as very separate grounds for liability, which they are, even though they both arose from the same underlying accusations against Johnny Depp, but they were different people saying different things at different times in different publications. Therefore, it's not the same transaction. It's not the same issue that is at stake in both of the litigations. And so for those reasons, both the privity argument precluded both the res judicata and the collateral estoppel arguments that Amber Heard had tried to raise. She had also made an argument that this requirement was not really a requirement anymore in Virginia, and the judge shut that down very firmly. She pointed out that the case law that Amber Heard was relying on to make this argument was from 1927, and that there were quite a few subsequent decisions to that that upheld the requirement that there be mutuality. And so that portion of Amber Heard's argument was not particularly well taken. At one point, the judge characterized her argument as fallacious, to the extent that she suggested one of these cases actually stood for a proposition that was the opposite of what it really did. So the judge certainly caught that and called that out. And thirdly, the argument regarding comity. Comity is this idea that sovereign governments should show respect for each other's processes. And the judge essentially noted a couple things. One, that there's an enormous amount of substantive and procedural differences in the law between Virginia and the UK. She called out my particular favorite, which is the portion of the Virginia Constitution, which states that the right to a trial by jury is superior to all other and should be held sacred. So Thomas Jefferson's Virginia, a single judge deciding that he wants to believe somebody for political reasons is not going to fly for due process purposes in Judge Azcarati's court. So that was pretty awesome. But she also noted that in any case, comity is a matter of courtesy. It's not a matter of one jurisdiction being legally obligated to recognize the judgments of another jurisdiction. And so based on that, the fact that Amber Heard had not been a party to the case in the UK meant that she wasn't subject to discovery requirements, and that significantly undermined the argument that he got a full and fair trial on the basis of her not having to essentially disclose a significant amount of the evidence that she's now had to disclose in Virginia. So the last real substantive argument that the opinion makes concerns the Uniform Foreign Country Money Judgments Act. I think that's what it was, something like that. Anyway, this statute in Virginia that allows for recognition of judgments from foreign jurisdictions to be recognized in Virginia between those same parties. This statute, again, suffered from the same defect as the collateral estoppel and res judicata arguments, which was that they're not the same parties. Amber Heard wasn't a party to the UK case, therefore she doesn't get to rely on the statute that gives that protection between the parties. So then, not substantively, but sort of related, the court did specifically call out and address one of Amber Heard's arguments that if the court did not recognize the UK judgment, that this would have a some type of chilling effect or parade of horribles on what she characterized as libel tourism, where people would shop for jurisdictions and retry their claims over and over again in an effort to find a friendly jurisdiction. And so Judge Azcarati turned that argument directly on its head, which I thought was pretty brilliant, because she pointed out that actually it's the opposite that's the case, that if we go and just give full credit to this judgment from the UK, which doesn't have the First Amendment protections that the US does, it doesn't have the procedural protections, the right to the jury trial, and so forth, then that's actually what's going to encourage people to be getting their trials done in the UK rather than in Virginia, where the accused would have a lot more rights to defend themselves, to challenge the accusations through discovery and investigation, and so forth. So that, in a nutshell, is the opinion. She did decline to impose sanctions, although she noted that I just wrote this down. The Amber Heard's argument was misguided and only thinly supported by existing law. She did conclude that it was not sanctionable. This is a judgment call on the judge's part. She doesn't have to find it sanctionable or not. From a practical standpoint, had she found it sanctionable, that order is far more likely to be appealed than an order that it's not sanctionable. Just for a variety of reasons, but the incentives are the main ones. A person who is, penalized tens, possibly, more thousands of dollars for bringing a frivolous lawsuit has a pretty strong incentive to fight that at the appellate level, as opposed to a person who's already bearing their costs of litigation. So it doesn't surprise me that she didn't find it sanctionable. I certainly think she could have. And one of the things that I noted from the opinion was the numerous places where she did appear to speak fairly directly to Elaine Breedhoft, who's Amber Heard's attorney. She called out, as I mentioned before, some of her legal arguments as fallacious, especially puzzling, that she would argue res judicata. One of the things she called out was that apparently during oral argument, Elaine had made a statement to the effect that Virginia had never declined to apply comity to a foreign judgment, possibly from the UK. And the judge said, no, that's actually not correct. Here's a citation to a case where that happened. And so these were all, from my standpoint, pretty pointed messages to Elaine that the judge sees her and the judge sees through how she argues and these kinds of strategies that she pursues in bringing her case. So the judge kind of underscored this point a little bit more, I think, with the fact that the opinion was extremely thoroughly researched. A number of the cases that she relied upon were not cases that were cited by either party in their briefs. So this isn't a situation where she just went through and, lifted one of the party's arguments out of their brief and put her name on it and called it her opinion. She went out and did her own independent research and thinking and wrote her opinion accordingly. So this is also a very clear message to Elaine that you're not going to slip anything by me here. If you think you're going to be able to exaggerate what the law is or twist the law into something that it's not, I'm going to catch you at it. So I think in that respect, while she did decline to impose sanctions in this particular case, we can see it as a little bit of a warning sign that essentially, hey, you can try to pull this stuff, but I'm going to catch you if you do. Last thing I just wanted to bring up real quickly was the issue of appeal, because I know a lot of people are going to want to know, is this appealable? Is she going to appeal it? And the answer is yes, it is an appealable ruling. Essentially, any legal question that the court is asked to rule upon, such as whether these particular doctrines apply and should preclude a judgment in this case, is well within the type of question that the Court of Appeals will typically take up in a case. But the main issue, though, is the timing of when that happens. This does not mean that she can appeal it immediately. Normally, an appeal can only be taken after a final judgment has been entered in a case. And so that means either it's been gone to trial and there's been a verdict and a judgment entered, or it's been dismissed on the merits for some reason before the trial. And the idea is because the court doesn't want to have cases being appealed piecemeal, because there's hundreds, if not thousands of rulings that can be made over the course of a case's life. And so if every single one were appealed when it happened, it would go up, it would come back down, there'd be a new ruling, it would go up, it would come back down, and things would basically never get to trial. So the idea is you wait until everything is done, and then you raise all of your issues at that point in time. And if any of those then proved to have been erroneous, then the court will look at what the remedy for that should be. It may be a new trial under some circumstances. It may be a revision of the judgment. It just depends on what the issues are. But so the bottom line is that she will be able to appeal this, but it's not likely that she would be able to appeal it before the trial is concluded and judgment is entered in the case. Now, there is the possibility of what's called an interlocutory appeal. And this is a situation where it's basically the exception to what I just said, where the court will, on very rare occasions, take up an issue before the case has become complete. But that's extremely unlikely to apply in this case because interlocutory review is very disfavored. And so the standard for it is extremely demanding, and it usually requires a showing of something like clear error by the court, and substantial impairment of the rights of the parties as a result of the ruling, were it allowed to stand and the case proceed with that ruling given effect. So given that, as Judge Azcarate has pointed out, the motion was misguided and only thinly supported by existing law at best anyway, it's almost a certainty that Amber is not going to be able to meet this standard. And so, no, there is not going to be an interlocutory appeal. There is not going to be a stay of discovery or a stay of the trial while she tries to do that. She may very well ask, but those attempts are not going to be successful. So all in all, that is the ruling on the plea and bar. It's unquestionably a big victory for Johnny Depp, if not a surprising one, nevertheless, one that I think gives a lot of validation to those of us who watched the UK trial and just recoiled with horror at the idea that that judgment would substitute for the decision of a jury after full discovery in the state of Virginia. So onward and upward, and we'll see you at trial.